One of the most common contractual problems I have found in H-1B employment is contracts that are actually in violation of immigration law. My general advice to businesses is try to avoid liquidated damages provisions in your contracts. Again, if I have time today, I would love to get into it. I have recently written a fairly detailed articles, and the citation is volume 58, number 5, page 37 of the Practical Lawyer. It's an American Bar Association, American Law Institute publication. If you are interested in the topic, you could get that article, and if you don't find it, you can always send us an email, pick up the phone, call us. I'll be happy to share the article with you. I'll also post it on our website. It will be there on our website, so you can download it from there, about the consequences of liquidated damages clause. See, the biggest problem in liquidated damages clause is, first of all, the regular problem which is there in all liquidated damages clause. We need to distinguish between penalty and liquidated damages. In order for something to be called liquidated damage, it has to meet certain requirements. Damages are uncertain. We don't know how much it's going to cost us if this happens. And this is a reasonable estimate. We're not trying to hurt the individual. So all these things are combined into the state law determination of what is liquidated damages. On top of that, we have a slew of interpretations now which talk about ordinary business expenses. Okay, so ordinary business expenses cannot be chalked off and made a part of liquidated damages. The law won't allow it. We have some cases in the handout. One of them is the Novinvest case. In this case, the employment contract required that the employees pay back $5,000 of investment fee. That was captioned relocation assistance in the contract. So the idea was, the company said, we invest considerable time, effort, and financial resources in organizing, assisting, and transitioning the employee to life in the US. So approximate cost is $5,000. If you stay with us 12 months, you are fine, because every month we will forgive 1/12 of $5,000. So in the 12th month, you have no liability. And the court said, no, this is definitely an early termination penalty. This is good law. It has been followed and quoted extensively. The Kuti case is another case where I think the employer was made to give several $1 million. I forget how many $1 million in back wages, etc. So Dr. Kuti operated medical clinics in Tennessee and hired 17 doctors. All of them had a visa called J-1 visa. Mr. Kuti and his wife jointly operated this practice. He started cutting on a doctor's salaries. So the court said, you cannot do that. And you cannot take the expenses of obtaining the H-1 visa. And the interesting thing is, even the J-1 waiver, which is part of the H-1 process, but not really H-1 itself. So something that leads up to H-1 is also ordinary business expense. This radically expanded the definition of business expense. Again, don't want to bore you to tears, but it's important. It's important to understand that what is an ordinary business expense. This is an evolving concept, and it is best to treat it very gingerly. This is dynamite. This case is very noteworthy because here personal liability corporate veil was pierced and Dr. Kuti was held personally liable. Okay. Currently this case is pending an appeal before the circuit court. So we don't know what's going to come of it, but right now it's still pending. Another case, which is the Greater Missouri medical case, is a good case to read for the law and the way Department of Labor thinks and proceeds. It's a lengthy case, but I think for somebody, again, I've tried to present information in a pyramid. The least you need to know, more you want to know. So whatever I could provide you for curiosity or satisfying your need for further knowledge, I have tried to do that.